Over the years, state law and case law have made the area of deadly physical force very complex. Lawyers, juries, academics, public officials, and the press have debated the issue every time a police officer has used deadly physical force. They all have the advantage of hindsight and time to reflect on this most important issue. You, on the other hand, are expected to act instantly and correctly. The policy of the Suffolk County Police Department is simple. It condenses this tough, intricate topic into one easy statement. Use deadly physical force to protect yourself or another from deadly physical force. Know the law and let policy be your guide. Remember, policy is there to help you. Keep up the good work, and thanks for your attention.
Don't anybody move. This is a stick-up. I just want money. Nobody's gonna get hurt. Let's go. Stay calm. Nobody get hurt. Let's go.
At the completion of this program, you will be required to, without aid of notes, indicate the correct statement concerning Article 35 of the New York State Penal Law, the impact of Tennessee versus Garner on Article 35, Suffolk County Police Department rules, procedures, and policy on deadly physical force, and the simplest and safest approach to the use of deadly physical force. First, let's define deadly physical force. It is physical force which, under the circumstances, is readily capable of causing death or other serious physical injury. Again, it's force readily capable of causing death or other serious physical injury. Even if it doesn't hurt someone, you may have used deadly physical force. It only has to be readily capable of causing death or other serious physical injury. Now, there are 4 authorities which govern our actions in this area. They are New York State Penal Law, Case Law, Department Rules and Procedures, and Department Policy. All of these fall into the category of what a professional should know. Policy will give you a concept, a mentality that will keep you within the limits of the law. It's basic, instinctual. It tells you, for you, deadly physical force is defensive. Only use it to defend yourself or another from being killed. The reason for knowing state law, case law, and rules and procedures is that you are expected to be as professional as possible. Your credibility may suffer if you don't know what is expected of you. Let's take a quick look at Article 35 of the New York State Penal Law to see what's expected of you. It's important to remember the law requires necessity. Necessity means you have no alternative. No other option existed. Your actions must not be reckless. You cannot disregard the harm your actions may cause others. Remember, Article 35 of the Penal Law provides authorization, but it does not command you to shoot. It simply says when you may. You may use deadly physical force to prevent or terminate these situations, to stop someone from using deadly physical force. Now here, there is a duty to retreat. Unless it's your dwelling and you didn't start the aggression, or you're a police or peace officer, or acting at an officer's direction. To prevent or terminate a robbery, burglary of an occupied building or dwelling, arson to a premises, forcible rape, kidnapping, forcible sodomy. To review, penal law authorizes, when necessary and without being reckless, the use of deadly physical force in these situations. In the arrest-escape area, there is a significant difference between authorization for civilians and police officers. Authorization for civilians is related to the crimes of murder, robbery, manslaughter 1, rape forcible, sodomy forcible. The crime must have actually occurred, and the suspect must be in immediate flight. Now, if a suspect has attempted these crimes, a civilian is not authorized to use deadly physical force. It should be noted that a civilian may also use deadly physical force if directed to do so by an officer, unless the civilian knows that in this situation, deadly physical force is not authorized. To review, the penal law authorizes, when necessary and without recklessness, the use of deadly physical force to arrest or prevent the escape of a person who has committed the following. As a police officer, you have the same authority in this area as a civilian. Plus, the penal law authorizes a police officer to use deadly physical force to arrest or prevent the escape of a person who has committed a felony involving physical force, certain designated felonies, or in attempting a felony and in resisting or escaping, he is armed with a deadly weapon or firearm. It is the department's opinion that authorization for the use of deadly physical force has been effectively removed in these particular areas. The courts, as you know, interpret and change law. Tennessee versus Garner is the case the Supreme Court ruled on that brought about this change. First, let's look at what happened and then the effect of Tennessee versus Garner on you as a police officer. At 10:45 p.m., a Memphis police officer responded to a prowler in a house call. He was met by a neighbor who said she had heard breaking glass. The officer went to the rear of the house. He heard a door slam, and he saw someone run across the yard to a chain link fence. Using his flashlight, he was able to see the suspect's face and hands. And the officer testified that he thought the suspect was 17 or 18 years old, and though not certain, he was reasonably sure that the suspect was unarmed. The suspect began to climb over that fence, and there was no doubt in the officer's mind that if he made it, he would escape. The officer fired, killing him. The U.S. Supreme Court found that a police officer may not seize an unarmed, non-dangerous suspect by shooting him dead. The court went on to say that where the officer has probable cause to believe that the suspect poses of serious, it is reasonable to prevent escape by using deadly force. For example, if the suspect threatens the officer with a weapon, or there is probable cause to believe that he has committed a crime involving the infliction or threatened infliction of serious physical harm, deadly force may be used if necessary to prevent escape. In addition to state law and case law, the rules and procedures also deal with deadly physical force. It's simple. You are responsible for the use of firearms. You must know state law. You must know department policy. Policy is the most important guideline you have concerning deadly physical force. Policy is an ideal, a standard that your department expects you to live by. It is instinctive. Policy is most important, so read the policy manual. Make sure you know what is expected of you. Let's briefly review some of the sections. Except in the defense of self or another against deadly physical force, an officer should not use a firearm. This is the basic philosophy you should have. It will keep you alive and out of trouble. An officer is equipped with a firearm solely to defend himself or others against deadly physical force. An officer is authorized to use deadly physical force to arrest or prevent the escape of certain felons. Even in those felony situations, you or someone else must be in danger of being killed. Remember these two things and you'll be all right. Let this be your personal policy. Now, let's review. It's important to remember the law requires necessity. Necessity means you have no alternative. No other option existed. Your actions must not be reckless. You cannot disregard the harm your actions may cause others. Article 35 of the Penal Law provides authorization, but it does not command you to shoot. It simply says when you may. you may use deadly physical force to prevent or terminate these situations. In the arrest-escape area, there is a significant difference between authorization for civilians and police officers. Authorization for civilians is related to the crimes of the crime must have actually occurred, and the suspect must be in immediate flight. As a police officer, you have the same authority in this area as a civilian. Plus, the penal law authorizes a police officer to use deadly physical force to arrest or prevent the escape of a person who has committed the following: the courts, as you know, interpret and change law. Tennessee versus Garner was shown to limit state law. Our rules and procedures tell us we are responsible and we must know law and policy as they pertain to deadly physical force. Policy is most important because if you understand it and use it as your guide, it will keep you alive and well within the limits of law and departmental rules and procedures. The simplest and safest approach to the use of deadly physical force is to use it only to defend yourself or another from being killed. This concept is part of all 4 authorities.
All right, don't anybody move. Police! Don't move! Don't move!
You all right?
Yes, Sarge,
Okay.
I'm all right.
He's going to take care of the scene. You sure you're all right?
Yeah, I'm all right.
Did you notify the duty officer?
Not yet, sir.
Okay, I'll take care of the notifications. What I want you to do is I want you to sit down. I want you to write down exactly what happened.
If you remember nothing else from this program, let it be that you can meet the threat of deadly physical force with deadly physical force. Know the law and department policy so that you may never have to hesitate and be a loser in the end.